zoning, occasionally the village board will ask either the applicant or possibly an objector to provide testimony at the Board of Trustees meeting to clarify the testimony that was given at the Planning and Zoning Commission. So in that instance, that person is a witness, and in that instance, the person has the right under section 8.701 to request that his testimony not be recorded by the recording devices. In that instance, it would be up to the providing officer to then direct, under section 2.05 of the Open Meetings Act, that the recording devices be discontinued while that testimony is being given, and then they can be started up afterwards. So in order to give effect to that right of a witness, it was contemplated that it would be necessary for people to notify the chair that they were going to record the meeting. And in that instance, the chair would make an announcement to the witnesses who might testify at the meeting that they have this right to request that the recording equipment be discontinued during their testimony. Okay? And it's solely optional on behalf of the witness. So to effectuate that, you need to, the chair needs to be notified that the proceedings are being recorded. Now, an alternative to that, which I've mentioned to you but is not contained in the ordinance, would be to announce at every single meeting that the witnesses have this right, instead of just at the meeting where the proceedings are going to be recorded. So that's one opportunity that you have to do that. You should be advised, all the trustees should be advised, there is an Attorney General opinion out there that involves the Lake County Board of Review, which is a tax review body of the Lake County government. And in that case, a person requested to record the proceedings of the Board of Review of Lake County, and they were denied because of the rules of procedure there, which required them to give prior notice to the clerk of the Lake County Board prior to recording any meeting. And in fact, the clerk was not present at the meeting. The person requested ahead of time to record the meeting, was kind of given a little bit of a runaround, and then ended up being denied the right to record the meeting. In that case, the Illinois Attorney General indicated that the person was denied the rights of the Open Meeting Act, and directed the Lake County Board of Review to amend the rules to allow recording. That case, though, is a opinion by the Attorney General that is binding only on the Lake County Board of Review and the complainant, Mr. Shields, in that case. But nonetheless, if you go on the Attorney General's website, it's there for your review and should be taken into consideration when you decide this ordinance. The other thing I should tell you is that the Attorney General allows advisory opinions to be issued. So if you're concerned, if you retain the notice requirement, which is what was the subject of this binding opinion, one of the options you have is to, before passing the ordinance, is to submit it to the Attorney General and have them issue an advisory opinion on the subject of notice, or to be, for that matter, any part of the ordinance itself. So you do have that option also. Getting back to the ordinance, in addition to the notice requirement, which by no means is required, but if you so choose to leave it in there, would be part of the ordinance. Chapter 2.65 deals with both recording of open meetings, which is permitted, deals with the official recording of the open meetings, which would be recording prepared by the Village of Indian Head Park, and require then that video recording be posted on the village's website. It would also require that the custody of the recordings be kept by the village clerk in compliance with the requirements of the Local Records Act. Closed meetings, such as executive sessions, obviously would not be a recording that website. While they could be either videotaped and they're required to either be videotaped or audio taped, those video or audio tapes would be kept private until the board makes a determination that those tapes can be released to the public. Then the section 2.6520 deals with non-official recording of open meetings. And again, similarly, for the non-official recording, the open meetings may be recorded by someone using a recording device, and closed meetings would not be allowed to be recorded by a non-official recorder. Subsection C is where we talked about the notification. It would require just prior notification to the chairperson of the meeting, whether it be the village president or in the village president's absence, President Pro Tem, or if it's a planning and zoning commission, the chairman of the planning and zoning commission, that the recording is taking place, so that you could give the admonishment to the people in attendance that they have this right to not have their testimony recorded by the recording device. It provides for a location for the cameras to be located, so they don't obstruct the view of the public or members up here on the dais. It prohibits persons from operating the cameras, from standing on chairs, benches, or tables, prohibits the use of flash photography or artificial lighting devices that could disrupt the meeting, directs that tripods should be positioned not to create a tripping hazard, and that a loose wire shall be contained under the tripod. Subsection E prohibits disruption of the meetings, saying that persons who photograph or record the meeting shall restrict the movement of the camera, and that the presiding officer has the right to request that there be termination of the recording if in fact it disrupts the meeting. Lastly, subsection F, if some people need special accommodations in which to facilitate the recording of the meeting, they're requested to contact the presiding officer meeting at least 2 business days ahead of time, so that those special provisions, special accommodations for recording can be made. Lastly, subsection G basically repeats what I've explained about subsection 8-701 of the Code of Civil Procedure about the right of witnesses who don't wish to have their testimony recorded to inform the chair of that, and the chair would then direct the recording not to take place during that testimony. So in general, that's the explanation of the ordinance for your consideration, and I'm happy to answer any questions.
I would like to ask you at the beginning, with respect to the notification of the recording, this, as the proposal here, the draft talks about giving the notice in writing to the presiding officer at that particular meeting, whether it be a board meeting or one of the other committees, and this is for the unofficial recording of the meeting. In writing prior to the commencement of the meeting, would it be sufficient if there was some kind of 5x7 form that, in effect, that a person could fill out name and address, that's pre-printed, that I intend to record, and then check boxes, audio, video, whatever method they use, and that we have that available, and that they would fill that out and then present it to the presiding officer before the meeting? That could be a form of written, doesn't have to be a special letter or so forth, does it?
Well, I mean, clearly that would comply if you had forms available for people to fill out. But to be honest with you, the only reason for the in-writing portion is, you can see up here at the dais, there's a lot of pieces of paper and things like that. And to avoid a situation where someone orally tells the presiding officer and then he, because he doesn't have a piece of paper to remind him, fails to inform the crowd, the idea was to provide you with just a note or something, a piece of paper, blank piece of paper I intend to record, post-it note, anything like that, just so that you have some type of memorandum in front of you as the chairman of the meeting to remind you that you need to make an announcement to the crowd.
Or we make it an automatic, we give notice prior to every meeting. We ask for people to identify if they intend to record the meeting, or to let people know that they may be recorded without asking if they're just
Yes.
have a, and we would do that at every official meeting of the board or any commission,
Any open meeting.
any open meeting, anything subject to Open Meetings Act.
Correct.
I have one more question, bear with me for a second. If we were to consider, discuss this ordinance and get it to a point where it was acceptable to the board, that we could, if I understood this right, we could then take what would later become the final ordinance, but take that final draft, submit it to the Illinois Attorney General, and ask for an advisory opinion as to whether or not this would comply with Open Meetings Act.
Yes.
Okay. Well, I personally would, so we can do without having the written prior notice. Because I personally would prefer to, we could go ahead and say, I think we need to get some regulations about this. However, I think we can see how it goes, and hopefully the presiding officers at the various meetings won't forget to make a statement. In fact, we could have a card prepared and presented up here. The meetings tend to take place in this room anyway, and that at the beginning, coincident, before or after you tell us when it should be, the Pledge of Allegiance, we issue that statement that notifies the witnesses of their right under the Code of Civil Procedure. So we could handle it that way.
Surely could do that.
Okay. So with respect to this draft ordinance here, I would ask the board to consider at this point, and if you want to argue the other way, that's fine, but my recommendation would be to adopt this ordinance, having deleted first the paragraph C called notification of recording, relabeling all the subsequent paragraphs, that would be B through G, and otherwise verifying that the document is internally consistent with cross-references after that point because of, or actually before, because of that deletion. So we're considering this ordinance with paragraph C having been deleted, and I'll ask the trustees questions or comments about it. And also, I would not be opposed to us asking, once we get it to a final form, to submit it to the Attorney General for an advisory opinion, if you think that's appropriate or necessary, or you would prefer to do it.
If I might make one possible recommendation, rather than deleting section C, I would suggest that you leave the last sentence and take out the word of any meeting being recorded by tape or other means, and just say the presiding officer of any public meeting, commencement of public meeting, shall announce the persons in attendance at the meeting if the meeting can be subject to recording. Something along those lines.
Okay, so we would delete paragraph C, keeping the label notification of recording, but deleting all the wording beginning with the words the use of secret all the way to the last sentence. And then have the last sentence read the presiding officer of any public meeting, and then delete the words being recorded by tape, film, or other means. Then it will continue to read, shall at the commencement of the public meeting announce to the persons in attendance at the meeting that the meeting is being, or may be recorded. So the words at the end of that sentence would be that the meeting may be recorded. Has everybody followed that wording change? Trustees? Okay, hearing no complaints, all right. We're at that point now, so we've deleted the bulk of the notification of recording requirement, other than say the presiding officer at the beginning of a meeting will announce to the people that they may, that the meeting may be recorded. So we keep the labeling for that paragraph, and then whether it, that would be my presentation of this ordinance that I would recommend that we adopt. And secondly, whether or not there's a preference to send it to the Illinois Attorney General for an advisory opinion in this format, with whatever other discussion might be.
I would think that would be a good idea, to send it to the Attorney General. That would be my opinion.
I would agree.
Other than the, are the trustees okay then with the document with that modification? And with apparently some consensus to send it to the Attorney General? Trustee Hinshaw?
I had questions about it, not about section C, but just questions about the document. Is this the right time
Yes?
to ask?
Yes.
Earlier today, Rich, we talked, I think you said that we would talk about something on the agenda and then ask the audience if they wanted to comment.
Yes.
All right, so we didn't do it on the last ordinance, but we'll do it for this one?
Yes.
Okay. Can I ask another question?
Yes.
On item D, location of cameras, audio and video recording devices, does that mean if a reporter is here and has, you know, the little cassette player or whatever the reporters have these days, do they have to take that to the back, or do they have to stand in the back?
They would have to use it in the area designated for recording. And so if we're designating the back of the room, then I would say yes, that's where we would record from.
So the same would be if I want to record a section of the meeting on my phone to, you know, listen to it later tomorrow to get better clarification, I would have to go to the back with my phone?
That's a good question, and I don't know the answer to that.
Well, it would be up to the presiding officer of the meeting. He just needs to designate an area, and it may not be the back of the room, but just somewhere where it does not obstruct the view of the public or members of the audience in attendance of the meeting. It doesn't necessarily need to be in the back, just someplace that doesn't obstruct the view of everyone.
I'm not a
Cell phone's not going.
attorney, and I don't stay at a Holiday Inn, so I don't pretend to be one, but looking at the Attorney General's site, the binding opinion, it seemed like what they were targeting in the back of the room in our example was tripod equipment. I believe they were saying handheld devices, you know, something I could sit in the front row and record. I believe that's what they were saying, so I don't think they were saying everything needed to be back, just things that were tripod and shape or type.
Can I make a comment on that point?
Yes.
My understanding of the Open Meetings Act and this ordinance is that if a witness comes here and testifies, and it is to be broadcast, so if a reporter is sitting here taping it and they're sitting in the front row, but the witness has no clue that that person is taping them and may broadcast it later on television, I would think that would be a problem, wouldn't it? Wouldn't we need to have everyone in the right area, in the same area, so we know who exactly is doing the broadcasting? And if the witness says, I don't want to testify with that person recording it, that we can make sure that the cameras are turned off and the recorders are turned off, so that later they don't broadcast it?
That's one of the reasons why it was originally drafted for notification ahead of time, so you know who was recording and who wasn't, so that you could have some control over when a witness objects to the recording, that those recordings were terminated. But, I think Trustee Hinshaw's question is slightly different. If it's a small recording device, and even if you're aware of it, does it need to be in the back of the room? And I think probably the answer is no, it doesn't need to be in the back of the room, so long as it doesn't obstruct the view of the audience, observing the meeting, and the view of the board members observing the audience.
I guess my question is, wouldn't it make it easier on us and safer on us to make sure that we know who's recording it and we make sure they turn off their device versus somebody sitting in the middle here who's recording this and we don't know that we can make sure the cameras are off, but we don't know that that person sitting there is turning off their recording device or not. If they're in the back, someone can go back there and make sure that we know who has the recording, and we can make sure that they turn it off. I mean, I'm all for taping. I'm hoping everybody watches these. Unfortunately, I've looked on YouTube. Some of these recordings have 3 views, and 2 of them are probably mine. So I hope people watch them, but, and I'm all for taping them, watching them, but I just want to make sure that we don't have any problems or anything in the future here.
I just have a
Trustee.
comment, and I'd like to share this with you at some point. I think that, the reason why we have an Open Meetings Act is because we want to have open meetings. And I think the more legal paragraphs that we put around open meetings, regarding this. Many villages that videotape their meetings have no ordinance like it. I checked in Sterling today in codification. Western Springs has live feeds and videos. They have no video ordinance today. That doesn't mean they may not have one, but we have not had a problem to this point with our videotaping at this point. We've had no problem with the situation. If there was a problem to happen, I would think that we would work swiftly together. We do not have a lot of testifying going on here in a judicial way to our dais. And I would like to present just, there's 6 things we can say about video recording from a model ordinance that I got on the internet. And my feeling would be, and this is just my non-lawyer feeling, would be make it simple. If we have issues that open us to liability, then we can look at making it more restrictive. But why go into this with a provision that we already know the Attorney General has ruled invalid? So let the people know we are recording the meeting, so then when we have the situation of some type of testifying, that the people know to put the devices out. We can't stop a reporter from using a handheld device. As long as it's not noisy, it's not impeding anybody's meeting, the person should be able to record the meeting.
Nobody's saying that.
Right,
If I could, Brian.
So I'm just gonna give this to you, and you can do what you want with it.
But I appreciate that, that's your opinion. I disagree with your characterization of the Illinois Attorney General position arising from a factual situation for the Lake County Board that invalidates this procedure based on counsel's presentation. So I disagree with that characterization. And secondly, we all change places. Sometimes we want ordinances before something happens, and other times we want, let's wait and see if we have an issue, and then we pass the ordinance. I personally happen to think that, yes, we haven't had any problem with video recording. It's only been taking place now since, I think, June, July, August. We're 3 months into it. There's no track record here. I want to be proactive. I want to get something down that we can go by. How it's enforced is another matter. How tight or how loose we go. Knock on wood, we don't, number one, this is a nice turnout. It's probably more than double what we normally have at the meeting. And I don't know that, for example, video cameras like we have today are disruptive, or somebody with a recording device. I find it interesting to know that, Tom, I should end up on one of your audio recorders, because I know you're not the official recorder for this meeting, so all the provisions of the unofficial recording would then apply to you. So, as I read this ordinance, we would have to ask you if we kept the notification provision to notify the presiding officer at the board meeting, me, in writing prior to the meeting, that, oh, by the way, Rich, at some point, I'm gonna turn my cell phone on and record you and everybody else, and sometimes, and if that's what you want to do, the thing is this is gonna let people know that it's going on. And that's why I think it's appropriate for us to go forward and to actually adopt something like this now before we have a problem or an issue. Hopefully it never will come to that. And what have we lost by being proactive? Nothing, because it hasn't infringed on anybody's right. And nobody here is trying to say we're trying to prevent recording. We just want to let people know what their rights are. People have a right to record, and witnesses have a right not to be recorded, as the law says. So, like everything else in government, we have to balance it. That's my opinion on it. Trustee,
If we sent this ordinance to the Attorney General's office for an opinion on it, would we send that as a draft ordinance or after we've adopted it?
I think you're probably gonna wanna send it before you pass it, because if the Attorney General feels any of the provisions are not in compliance with the Means Act, you're gonna wanna know that before you pass it. That'd be my opinion.
Can I take one question?
sure.
And I'm not for the notice provision, I don't, but I just have to ask this question. If we take out that provision regarding notice, and someone comes here and testifies, again, we don't have it often, but it may happen, it happens certainly at zoning meetings, but if the whoever's presiding the meeting fails to read that document, and the person testifies and recorded, what are we, are we just in violation of the Open Meetings Act, or are we subject to something from the person who testified?
There's no requirement under either the Open Meetings Act or 8701 that you give that notice. That's just to have the public be informed. I think the risk is the risk that you brought up earlier, without notice about who's recording. If a witness comes up and says, I don't want my testimony to be broadcast or recorded, and we don't know that someone's recording, I think then possibly, a complaint would be filed that we facilitated a violation of 8701 by not controlling the recording of the meeting.
But that could happen anyway, even if we did tell them, right?
Well, you could, but at
We
least
could
you've
say-
taken steps to, make it a situation where you've got a procedure in place that minimizes that. But yes, there could be, someone could not inform you of the recording and continue to record the meeting. Yes, that's true.
Trustee Walsh.
I agree with actually a lot of what everyone said. I do think we could probably make this a little more simpler. I'd like to see what Amy has, and maybe we can, there we go. So I'll take a look at that. The notification requirement I think is important, at least in the beginning of the meeting, so you can inform people that there's recording going on, so we can address it appropriately. As far as what Tom brought up, as far as the audio recording, I personally don't have a problem with someone that they have a audio recording in their lap. The danger becomes, and maybe you build in a discretion at the chair, is if somebody has that in their lap, that's one thing, but they're holding it up, recording it, like with an iPhone, it becomes a little more destructive. So, I think a lot of this we're going to kind of see how it goes, and, if you have discretion of the chair to ask people to move to the restricted area in the event that they're disrupted, you may solve all that. But personally, if a reporter is recording it, I don't think I necessarily have an objection or a problem, provided that we're giving the people in the audience notice.
Anybody else?
I handed Matt a one-page sample. I agree, simpler is better. I think if we have the revision and it looks like we're taking it out, we could potentially invite some cost if we were to get sued. I would like to change that section D so that I could record, or that anybody could record sitting in the chair, as long as they're not obstructing, making noise, excessive flash, like the ruling or the information says. So I would be for it if we could change item D, but as it is, we could not.
So Mayor, I would recommend that we table this until the next meeting. We have an opportunity to discuss and make some modifications to it. And then maybe at the next meeting, we can vote on whether or not we would be in approval of it, provided that's something we bring it down. And I do like the idea, since it is impacting the public, that the public has an opportunity to take a look at this prior to our action process.
Okay, I will hear what you just said as a motion to table the discussion to the next meeting.
Yes.
However, before let me ask for a second at this point.
Second.
Second by trustee Hinshaw, okay. I had said earlier, we're gonna hear from the audience, so you're here, thank you for coming out tonight. You've heard the discussion, I know you haven't had the actual opportunity, because you looked online in the last 2 days, it's been online, right?
Yeah.
This one's not, okay.
We didn't get
All right, I thought it was
I
just-
didn't put it.
All right, in any event, you heard council's overview, section by section of the ordinance. The first 3 or 4, I don't think anybody, I didn't hear anybody from the trustees say they had a problem. Deals with the official recording of an open meeting. Most of the wording, the discussion has been about the non-official recording. The newspaper reporter, the resident with the video camera, the trustee with the cell phone that records people, anybody else who might come with some kind of recording equipment. I would like to hear your input. I think we all would like to hear what input, what questions or comments you might have. Anybody?